Hello and welcome to today's webinar on getting to grips with data protection and subject access requests. My name is Mike Hibbard and with me today is Louise Merrill. Today we'll be looking at data subject access requests, otherwise known as SARs, and the best way for organisations to deal with these. We will be outlining what a subject access request is and what an organisation is required to do to discharge its obligations. From our experience in this area, we will then provide you with our top tips to help you effectively respond to a SAR. So today we will first look at what a SAR is and when they are used. We will then explore the requirements for a valid SAR. In the main part of the webinar, Louise and I will look at how to effectively respond to a SAR and the steps your organisation will need to take. We'll then look briefly at what may happen if you fail to comply with a SAR. We will then look at how the upcoming EU General Data Protection Regulation will impact on SARs. We will then look at common misconceptions we see with SARs and mistakes that organisations may make. And finally, we will set out for you our top tips for effectively dealing with SARs and recommendations of the key steps that you should be taking. Before we move on, it's important to note that we'll be using terminology from the legislation such as personal data, data controller and data subject. To recap, a data controller is the legal entity who decides the purposes and manner of the processing, for example an employer, and the data subject is the person about who the data is about, for example an employee. The definition of personal data is more complex and we explain this in detail in our first webinar in this series. If you are unsure about this definition, please make sure you listen back to the first webinar which talks you through this.
So, what is a SAR and when are they used? Under the Data Protection Act, individuals have a right to make a subject access request to find out what information a data controller, such as an employer, holds on them. This is commonly referred to as the right of access. An individual's right of access can be broken down into 4 parts. The right to know if their personal data is being processed, the right to be given a description of that data, together with details of the purposes behind the processing and the class of recipients who may see the data, the right to have the personal data communicated in an intelligible form, together with any information on the source of that data, and finally, where decisions about the individual are made solely via automatic means, such as automated recruitment tools or creditworthiness tools, the individual has the right to be informed of the logic involved in that decision making. The purpose behind the right of access is to ensure that individuals have a way of checking that their personal data is not being misused and that it's accurate and up to date. However, we're seeing these requests being used more and more by disgruntled individuals when disputes arise, particularly where litigation is a possibility. Part of this will be so individuals can assess the likely merits of their claim before deciding whether or not to bring a claim. However, in many cases, it's a tactic used to apply pressure, often with a view to encouraging settlement discussions.
So what are the requirements for a valid SAR? The threshold itself for a valid SAR is low. All that needs to be met under the DPA, Data Protection Act, is that the request is in writing. This can be by email, and the ICO even suggests that social media could qualify. While organisations may have a standard pro forma for SARs to be completed on, if individuals decide to not use this, the request can still be valid. A request is also valid even if it is sent to an individual in the organisation who does not deal with SARs usually, and therefore it should be passed on to the proper person immediately. A data controller is entitled to charge a fee of up to £10, and if wishing to use this, it's useful to include it in the requirement of any data protection policy so there's no doubt for individuals. A data controller may also ask for evidence to confirm the identity of the individual. We strongly recommend you take this step to ensure that the person asking for the data is who they say they are, especially if the request is by email or by social media. If a request was made by someone else and no checks were done, by supplying the data required under a SAR, you could actually be carrying out a data protection breach. For employers, a quick verification with their employees should be easy to do to confirm they have made the request. If the request comes from a third party, the third party should also provide written authority. In the case of a solicitor, if the subject access request confirms the solicitor acts for the party in question and has authority, this barrier will usually be met, but there's no harm in asking for this anyway. So here we have an example of a valid SAR. If you just take a quick moment to read this, anyone who has dealt with a SAR before will know that the chances of getting such an obviously compliant request are low. This request is clearly valid as it is in writing, has preempted any requests for a fee, and has clarified the search terms and a third-party authority. This email was accompanied by a letter from Joe Bloggs confirming the solicitor in question had been authorised to submit a SAR on his behalf, in addition to the £10 fee and proof of identity. So turning to the requirements for the valid SAR, it was in writing. If requested by the data controller, it had the £10 fee and proof of ID, and it had the letter stating that the person was authorised to act on the third party, in this case Joe Bloggs' behalf. So let's have a look at some more examples and decide if these are valid. For example, Mr. Bloggs now calls the HR department of his employer, a company limited, and says he is making a subject access request. He then follows this up by speaking to HR directly. Clearly, this is not valid as it is not in writing. A company limited have their policy setting out that SARs must have a £10 fee accompanying them and evidence of the person making the request, and ask Mr. Bloggs to provide this in response to a written request he now makes. While he now has a written request, as the data controller has requested ID and a fee, it will not be valid until this happens. How about the following? Mrs. Bloggs at hotmail.com emails a company limited's HR team and asks for all personal data on her husband. Here, the request is from a third party. While it is in writing, there is no evidence that Mrs. Bloggs has the authority to make the request on her husband's part, and we have no evidence of identity. We do not even know if this email address is from Mr. Bloggs' wife. As a further point, if a company limited did go back and ask for a fee, the request would not be valid until the fee was provided. So what should be done if a SAR is not valid? A response with a request for missing information or for a fee or proof of identity to the individual should be made without undue delay to inform the individual and allow them to rectify any defects.
So, you're tasked with dealing with SARs, and a SAR lands on your desk. Or does it? May sound simple, but the first step is to make sure that any SARs are directed to the right person who's been trained in how to deal with these. This could be your HR team, senior managers, or a particular person who fields these in the first instance. There are tight deadlines for responding, and so the quicker this gets to the right person, the better. Then consider if it's a valid SAR. As Mike has highlighted, it may be that you need to go back and clarify points with the individual, and you may also need to request a fee or identification documents. This should be done without unreasonable delay. Further, if you're unable to locate the individual's data without further information from the individual, then you can go back and request this. Note that this is only if you can't locate the data and need additional information to do so, such as details of who may hold the data or a particular date range. This can't be used simply to narrow down the request because it's onerous, which we'll touch on in more detail later. Then note the deadline. Requests must be complied with promptly and in any event within 40 calendar days, and so it's important to diarise this and bear it in mind as you progress the request. There's no scope currently for this to be extended, even if the request is onerous and likely to be very time-consuming. However, if you request identity documents, a fee, or additional information to allow you to locate the data, the 40 days won't start until this has been received. Before you comply with the request, it's worth checking if the individual has made a similar request before. and if so, if a reasonable time has lapsed since the last request. If not, you may be able to refuse to comply. Whether or not a reasonable time has passed will depend on many factors, including the nature of the data, the purpose for which the data is processed, and the frequency with which the data is altered. The ICO has issued Subject Access Request Code of Practice, which sets out more detail and practical advice on dealing with subject access requests, and this includes information on repeated requests. Next, think about keeping the individual informed. This is likely to make the whole process go a lot smoother and will go down well with the ICO. It's good practice to acknowledge receipt of the individual's request and to set out the time frame for compliance so you're all working towards the same understanding. Finally, make sure someone is assigned to oversee the process. At this stage, that person can consider all the potential sources of the individual's personal data, including manual files, electronic files, email accounts, and surveillance records like CCTV. They can consider the likely resources that they will need to comply with the request, including getting IT on board early and considering if a team will be required to help with the search and/or to help sift through the results afterwards. It may be that you need to search other people's email accounts, and if that's the case, you'll usually need to let them know that you're searching their systems. Ideally, you'll have a policy in place which clearly explains circumstances where you may need to monitor their communications, such as this. Any individuals who are likely to process personal data must be told not to delete anything as a result of the request. So now you're ready for the search.
Once the valid SAR has been received, organisations should start searching for the data, as there could be a huge volume of data, for example in emails. Consider how many emails go through your organisation day to day on individuals. The search that you have to do should be reasonable and proportionate. In practice, this does not give much of a defence for organisations. The ICO guidance states that extensive efforts should be made to find and retrieve requested information, and that it will never be reasonable to deny access merely because responding to the request may be labour-intensive or inconvenient. In a recent decision of the Court of Appeal in Dawson Damer and Taylor Wessing, it was highlighted that the reasonable and proportionate requirement relates to the entire SAR process, and this includes locating and retrieving the documents. In this case, the Court of Appeal held that a data controller would be required to identify such material, and then they can assert why this would be disproportionate to carry out the search. The hurdle for this is very high. Recent ICO guidance reflecting this ruling states that in assessing whether complying with a SAR would involve disproportionate effort, allows a data controller to take into account all difficulties in complying with a request, including those in finding the information. When conducting your search, consider nicknames and variants of an individual's name. For example, going back to our earlier slides, Joseph Blogs would need a number of searches carried out, for example on Joseph and Joe as well as Blogs. If the requester has a name that can often be misspelt, such as Catherine, which could be spelt with a K or a C, searches should be done under both to make sure the data can be found. While ideally the requester should give you this information in advance as part of the SAR, in practice this might not always be the case, so it should be considered by the people in your organisation conducting the search. So you need to do a reasonable and proportionate search, but what is disproportionate? The burden of proof is on the data controller to show it has taken all reasonable steps to comply. It is best practice to engage with an applicant and discuss exactly what information they require in order to help you locate the data. If an applicant later complains to the ICO about how their SAR has been handled, proactive engagement from the outset will help the ICO in determining whether to take any further steps. Given the high hurdle for disproportionate, we now set out some examples. A recent example of disproportionate effort was in Hollyoak versus Candy and CPC Group Limited, where the request extended to a search of directors' private email accounts. the company was not bound to ask for access unless there was a sufficient reason for doing so, and this was an intrusion requiring justification. Also, ICO guidance suggests that where information has been permanently deleted from computer systems, but could possibly be recovered by using expensive technical expertise, there may not be a requirement to undertake such measures.
So, you've got the results of your searches. What now? First, it's important to bear in mind that the individual does not have a right to see copy documents. The right is to have personal data communicated in an intelligible form. Therefore, if it wanted to, a data controller could lift the data subject's personal data from the original document and paste it into a newly created document which collates all of the personal data and information on the sources where available. In practice, however, it's often easier and more cost-effective to supply a copy of the documents themselves, with redactions covering any data not being disclosed. Most businesses provide results in hard copy. However, we would flag that for those who have software enabling them to make redactions online and submit results in soft copy, there is software available that can unredact such documents. Just something to bear in mind and to maybe speak to your IT team about. Now let's think about the content of the documents. They may contain a mixture of the data subject's personal data about other people, or information that's not personal data at all. The Data Protection Act also allows you to withhold personal data in some circumstances. Each document will therefore need to be reviewed. Let's start with the easy one. If the information does not contain personal data at all, it will not need to be disclosed. Consider, for example, an email to all staff setting out uniform requirements. The data subject is one of the recipients of the email, together with the rest of the business. The data subject's name features in the to field of the email, and this will be their personal data, save in the unlikely event that someone else within the business has the same name. However, the rest of the email won't be personal data and will not need to be disclosed. Now, in this scenario, no one is really going to want to see a heavily redacted document which leaves only an individual's name, and so practically this is a scenario where it makes sense to lift the personal data, i.e. the person's name, and refer to it in a separate document, or perhaps preferably in your cover letter to the data subject, together with details of the source of those emails. More difficulty comes when the information contains a third party's personal data as well as that of the data subject. Then the data controller needs to ensure it doesn't inadvertently breach its obligations towards the third party by revealing it. Generally, the starting point is to look at whether the third party data can be easily separated from the data subject's personal data. If it can, it's simple. The third party data can be redacted and the redacted documents sent to the data subject. The issue comes when a third party's data cannot be separated out. Where this is the case, the data controller can withhold the data subject's personal data unless the third party has consented to the disclosure or it's reasonable to disclose the information without the third party's consent. There's no legal obligation to try to get a third party's consent, however, it's good practice to do so. If the third party is approached and consents, then it will likely be unreasonable to withhold that data. If there's no consent, either because this hasn't been sought or the third party has refused, the question becomes, is it reasonable to disclose the data in any event? Relevant factors here will include whether there's a duty of confidentiality to the third party, whether you've tried to obtain consent, whether the third party is capable of giving consent or has refused consent, and whether the information is already known to the data subject or is in the public domain. Let's look at an example from the ICO guidance. On your screen is a letter from Mrs. Odman, who witnessed an incident involving her neighbour and a delivery man. The letter contains personal data of Mrs. Odman and Mr. O'Dwyer. The delivery man is not named, but it's likely his employer could identify him from other data it holds on him, and so it will constitute his personal data also. If Mrs. Odman made a request, it would be reasonable to disclose the letter to her without the third party's consent, as she wrote the letter and already knows the contents. If Mr. O'Dwyer made a request, it's also likely to be reasonable to provide him with a copy, as the letter is stated to be written on his behalf, and so it's likely he's aware of the contents. You could always seek Mrs. Odman's consent if you're unsure. If the delivery driver makes a request, it's likely that it would be reasonable not to provide him with the information. Whilst it's his personal data, given the nature of the incident, it's likely Mrs. Odman had an expectation of confidence. Again, consent could be sought if you're unsure. Finally, under the Data Protection Act, certain information is exempt from the right of access. There's quite a few of these exceptions, but here's some of the most common ones. Firstly, where information is protected by legal privilege. Secondly, where information relates to a confidential reference given in connection with education, training or employment, appointing office holders, or providing services. Thirdly, where the information is processed for management forecasting or planning, and disclosure would likely prejudice the business or other activity of the organisation, it can be withheld. So, for example, if a business draws up plans for redundancies but hasn't announced these to its workforce yet, then it may want to refuse to disclose these as part of a subject access request on the basis that this would prejudice the business by causing unrest with the rest of the staff in advance of the announcement. Finally, where the information consists of a record of your intentions in negotiations with an individual, it can be withheld if revealing this would prejudice those negotiations. The two latter categories are quite restrictive, and so if you are intending to rely on one of these, please make sure you seek advice. Before we move on, there's just one more thing I wanted to highlight with redactions. Imagine you're the data subject, Joe Bloggs, and you receive an email as part of your subject access request that looks like this. What are you thinking? Looks dodgy? Data controller has something to hide? Maybe Joe's an employee thinking of bringing a disability discrimination claim. This email might look very suspicious. However, an unredacted version shows that there wasn't really anything to be suspicious of. The redacting is simply to remove information that was not the data subject's personal data. This is really just to highlight the potential danger in over-redacting. Provided you're not revealing third-party data or sensitive information, you may want to take a view on whether you disclose more than you have to. Heavily redacting may lead an individual to think they found evidence to support a claim when this is simply not the case.
So now you've collated your data, let's look at what needs to go into the response. An individual is entitled to receive a copy of all the personal data an organisation holds, as well as information on whether any data is being processed. So if no personal data is held, the requester must be informed of this, a description of their personal data, the reasons it is being processed, whether it will be given to other organisations or people, and details of the source of the data if known. The information must be supplied in an intelligible form, so in most cases this means a hard copy of the personal information and data should be provided, unless this would involve a disproportionate effort. However, as we set out earlier, the hurdle for this is very high. Individuals are also entitled to information as to the source of the data, and if any codes have been used, these should also be explained.
If a data subject is unsatisfied with the response, they can complain to the ICO. The ICO will assess the situation and may issue an enforcement notice if it's satisfied that the data controller has breached its obligations. An enforcement notice will likely list specific steps for an organisation to take, and non-compliance with an enforcement notice is a criminal offence. An individual can also apply to the court to enforce a subject access request. In looking at whether to assist, the court will consider a number of factors, including whether there's a more appropriate route to disclosure. And so data subjects using a data access request during litigation may find it difficult to get the court on side. The ICO has no power to award compensation to individuals. However, this can be enforced through the courts. Generally speaking, save in relation to processing in the context of journalism, art and literature, the individual will need to demonstrate that he or she has suffered damage as a result of the breach, i.e. financial loss. If this is satisfied, the individual can then also recover compensation for distress, but they can't claim for distress alone. They have to show damage first. This may be a difficult hurdle for individuals in the context of subject access requests, where there's often no financial loss to them resulting from the breach.
So now we've looked at the position under the Data Protection Act, let us consider the upcoming General Data Regulation, which comes into effect in May 2018. We covered the regulation in detail in our last webinar, so please let Louise or I know if you'd like a copy of the recording. The GDPR will make a number of key changes to SARs, including the 40-day deadline for compliance will be reduced to 1 month, although it is possible to extend this by a further 2 months where requests are complex or numerous. If this is the case, you must inform the individual within 1 month of receipt of the request and explain why the extension is necessary. Subject access requests from employees may fall under this category, but we will need to await further guidance from the ICO. It is worth pointing out the definition of personal data is also expanded under the GDPR. For example, it will include genetic and biometric data, as well as online identifiers, which could bring most data collected and processed in the context of online behavioural advertising within the scope of the GDPR. Individuals will also have enhanced rights, including the ability to request additional details, which in any event will be included in the response, including the period in which the data is to be stored, as well as the rights to have their data erased or corrected. There will also be an ability to object or restrict processing. In addition, organisations will no longer be able to charge a £10 fee. However, they will have the option to refuse to comply with the request or charge a reasonable fee where a SAR is manifestly unfounded or excessive. The burden of proving this will be on the data controller, and what this will mean in practice is yet to be exactly determined, so will need to be used with caution. Organisations, when providing their response, will also need to inform individuals of the right to complain to the ICO and to judicial remedy, as touched on by Louise. Again, this could be viewed by organisations as giving a further weapon and option to individuals, but regardless, this will need to be included as part of a valid response. Finally, data processors will also have obligations on subject access requests once the regulation comes into effect. They will not simply be able to pass on a subject access request and say they are a data processor, so do not hold any data. So they will need to also consider their obligations come May next year.
We've put together a list of 5 common misconceptions that we've come across when assisting others with subject access requests. There will be a lot more, but for the purposes of this webinar, we've kept it to a top 5. So the first one, I do not need to comply with the SAR if it is a fishing expedition for possible litigation by the individual. We are seeing an increased amount of data access requests for this purpose. However, the case law is very clear. There's no basis for refusing to comply with the SAR based on an individual's motive. Data subjects need not even inform an organisation of any purposes behind their request.
Secondly, I can limit the search I have to do by asking further questions to the individual to limit the scope. Although organisations frequently do this, technically, a request for further information should not be used to limit the amount of data searched for. While further questions from the organisation may be useful, as they give organisations an idea of where to search and give them an idea of what's being looked for by the individual, even if the request points to a specific date range, the response should not just contain information within this limited time frame, and the response will need to have all the personal data that's been collated that the data controller holds. However, clarifying responses may make it easier for the organisation to fully respond to the subject access request within the time frame, as you may be pointed towards where the data is likely to be found.
I have a clear policy setting out how a SAR should be made. I don't need to comply until an individual satisfies this. It's good practice to have both a predefined form and a policy in relation to SARs. It's obviously clearer and helps you to manage the process more effectively. However, as long as a SAR is valid in the legal sense, it must be complied with, irrespective of whether the company's requirements have been met.
If the result brings up third-party data, I do not need to supply this data. As Louise has already set out today, if third-party information is within the results, consideration still needs to be made to the balancing exercise to see if the data can still be disclosed. Even if this exercise suggests that it cannot, consideration then needs to be made on whether the data could be supplied by redacting the third-party information. Practically, as we mentioned, when considering redaction, consider how this would look to an individual when deciding the level of redaction that you're going to carry out.
This SAR will take me weeks to comply with. Clearly, this time and cost to the business is disproportionate. There's a high expectation on data controllers to provide information in response to a SAR. As we've heard, they're required to make extensive efforts to find and retrieve the requested information. If it would be disproportionate or unreasonable to comply and you can demonstrate this, then you still can't refuse to comply on a blanket basis and will instead be expected to do whatever is proportionate in the circumstances.
So, having considered today's SARs in detail, on this slide we will outline our top tips on how to effectively deal with any SARs that you get coming in. So our first recommendation is to diarise key dates and assign responsibility from the outset. You can't avoid responding to the SAR, so you need to keep on top of the deadline, and by assigning responsibility, your organisation will know what needs to be done and, more importantly, who will do it. SARs are a commonly used tool by individuals, so organisations need to start improving their efficiencies to ensure they can deal with the administrative burdens. Remember, the timeline for compliance starts once the valid SAR is provided. If a fee is requested until May next year, the 40-day deadline won't start until you receive this. Secondly, we recommend having an optional standard form for making the SAR. This could invite the requesters to give details of the information requested. We also recommend making a template response wording that can be adapted for each SAR received. Reducing the time to draft individual responses will make it much easier to comply with the SAR deadlines and will ensure nothing is missed from the response that could come up and make a complaint to the ICO. Thirdly, when you're collating your papers, always have a mind on what is personal data. An individual is only entitled to their own personal data, and you are likely to find that once you take out information that isn't their personal data, the bundle of papers to be disclosed will be significantly reduced. Fourth, you should consider implementing a policy and structure to ensure SARs are processed and responded to effectively within the appropriate timeframe. This policy should also consider when you would be likely to consider a request to be complex or numerous, so potentially falling under the grounds for an extension to respond under the GDPR. And if you want the possibility to bring a fee for repeat requests after the GDPR comes in, the grounds on which your organisation may deem requests to be manifestly unfounded or excessive. Fifth, you should consider a retention and deletion policy in relation to the personal data. Different time periods may apply depending on the type and purpose of the information. Remember, under the GDPR, May next year, informing an individual of how long their data will be retained is one of the requirements of what will need to be included in your response. Sixth, make sure you'll be able to comply with the additional measures imposed by the GDPR that I touched on earlier, especially the quicker time frame to respond, as well as no longer being able to charge a £10 administrative fee. Additional resources within your organisation may be required to collate all the information and provide the responses. Finally, and this really is a key tip, review the data before you send it. To avoid any inadvertent disclosures or wrongful disclosure of third-party data, it is good to have someone else review this data before it goes out. Once you've collated your data for the subject access request, you're likely to have a huge volume of documents, and mistakes can easily be made. An example provided from the ICO, although not in the context of the SAR, is Basildon Borough Council recently being fined £150,000 for sensitive personal data being published online as part of a planning application document by an inexperienced council officer. Here, the data hadn't been checked by a more senior colleague before it went up, and the ICO found this to have been a significant breach. It shows the merits and the worthiness of just getting someone to check the data before it goes out. On this slide, we've put some useful links to ICO guidance, checklists and code of practice on subject access requests. If you need any further information on these, of course, please get in touch. So that concludes today's webinar on subject access requests. We hope that you now have a better understanding of what they're used for and how you need to respond, and the best steps you can take to comply lawfully within the deadlines. Remember, at Clarkslegal, we're highly experienced at dealing with subject access requests, including redacting third-party data and applying exemptions, so do contact us if you have any questions or would like any assistance with the SAR you do receive. Mine and Louise's contact details are on this slide, and we also have contact with HR consultants specifically trained to deal with high-volume SARs. Our next webinar on the data protection series will be on the data protection aspects of commercial agreements, and this will be on Monday the 9th of October. Thank you for joining us today, and I hope you can make it next time.